Thanks, Veronica. Welcome, everyone, to Pro Bono Partnerships seminar today. Think before you sign, considerations for nonprofits entering into contracts. I'm Barka Patel. I'm the Director of Education and Counsel here at PBPO. We are excited to bring this to you with our speaker, Jerrad Howard, who's a partner at Dinsmore and Shohl. But before we get started, we'd like to just go over a little bit more about PBPO for those of you who are not as familiar with us. So this program is supported by the generosity of the L&L Nippert Charitable Foundation. We also want to thank all of our 2022 corporate sponsors listed here on this slide. And we want to share our mission. Powered by attorney volunteers, we strengthen our community by providing free business legal services and education to nonprofits. This is a slide that we're very proud of. We have over 800 attorney volunteers providing free legal assistance to over 280 local nonprofit clients. We worked on over 2,000 different legal matters for about $7.9 million worth of free legal services provided to these clients. In addition, we've hosted over 125 workshops and educational seminars for nonprofit leaders. So this is just some of the criteria for becoming a PBPO client. You can read it here, and you're always welcome to reach out to us. I'll share our information here in a moment, and reach out to us to discuss whether your organization qualifies to become one of our clients. This is just a sample of some of the legal projects that we handle. But of course, we review contracts for our clients, board documents and responsibilities. We work with our clients on employment matters, intellectual property, fundraising, real estate. The list goes on and on, but with over 800 attorney volunteers, we are almost always, if not always, able to find a qualified attorney to work with our clients on all of their legal needs. Our clients can expect from us quality legal services from experienced attorney volunteers. They can expect to work with their own PBPO attorney on staff that's skilled in the area of nonprofit law and tax-exempt law. We help them issue spot and identify areas of risk. We always place our matters with subject matter experts with a PBPO attorney overseeing each and every matter. And finally, what we hear most from our nonprofit friends is we don't know what we don't know. And that's why we put on seminars like the one today to help our nonprofit friends and members of our community understand the things that they do need to know to make sure that their nonprofits are strong and continue to serve our community. If you'd like to learn about applying to become a client or joining our mailing list, or have any questions in general, feel free to reach out to us. Our information is on this slide. And for today, Jerrad is happy to answer questions on the content of this webinar. So feel free to put questions about content in the Q&A that you'll see on your screen. And welcome. So think before you sign, considerations for nonprofits entering into contracts. Jerrad Howard, as I mentioned, is a partner at Dinsmore and Shohl. He's also one of our valued volunteers and serves on PBPO's advisory council. So Jerrad, thank you so much for doing one more thing for us and speaking for us on this. We're so excited to share your expertise with our nonprofit community.
Perfect. Thank you so much, Barka. If you'd like, I will share my screen now, and we will get into the presentation. Great, everybody. So again, Barka has already given me kind of the introduction, but I'll just tell you, I am a partner at Dinsmore and Shohl based in Cincinnati. I've been with Dinsmore for over a decade, and my specialty is corporate, specifically M&A, but I also spend a significant amount of time advising clients, boards, executive teams on a whole host of corporate issues, whether it go from funding and financing to approvals to M&A transactions, strategic decisions. So that's it. I will give you all a warning ahead of time. You may hear some barking in the background. I never know when my favorite little doodle, who usually sits under my desk, will decide to be very vocal. This is a picture of my doodle. So if you hear any barking, I apologize ahead of time, but at least you know that she's adorable and is alive and well, for what that's worth. I just wanted to go through the agenda really quick. Before then, we hop into a poll that'll kind of frame the initial discussion. But just to give you an idea of what we're going to cover today, we're going to first talk about why we have contracts in general. And we'll talk about some common types of contracts and the main elements of contracts. And then we'll switch over to kind of some of the post-signing pieces of contracts. What do we do after we sign the contracts? What do we do when there's a problem? What if we need to modify it? And last stage, what do we need to do if we need to get out of a contract? So we'll cover each of those in detail. As Berger said at the very beginning, please feel free to ask questions. I would like this to be as interactive as possible as we go through. It's also sometimes easier to answer questions when we're still on a slide or close to the slide, so that we're still on the same subject and don't have to try to backtrack and figure out what exactly I said, because you never know what I might say. So with that said, we have 2 questions for you. So Veronica, if you can run those, that would be great. So the first one is, which of the following best describes how you feel when you receive a new contract in your organization? It's either the most important thing in the world, it's just one more task that needs to be done, or let's just sign it and move on. We've got people to help, and this is a waste of our time. I should have, prepared a song and dance number while we're waiting, or at least some Jeopardy music in the background while you are answering the poll questions. Unfortunately, I'm not that clever. Great. Okay. So the good news is nobody said, one person said, let's just sign it and let's just move on. So the person who responded to that one, this webinar is for you. For those who responded with, it's the most important thing in the world, there's a few of you. I appreciate your zealous attitude toward your contracts. But really, what I hope to get from this webinar and teach each of you is, contracts are nothing to get stressed out about, but they are important, and we need to treat them as important because they will govern your relationship moving forward with whoever that is. Veronica, if you want to run the second poll, great. And so this question, guys, this is not me acting as a broker on insurance policies. I just wanted to know how many insurance policies your organization has. I promise this will be topical and it'll make sense in a second, but either none, 1 or 2 policies, or 3 or more policies. Three or more policies is the winner here. 1 or 2 policies is still there. Okay, great. So thank you everybody for answering those questions. And I want to just hop right into the next one. So why do we have contracts? So the reason why I asked the question about the insurance policies is because you should actually think of contracts as basically an insurance policy. It really it functions in a similar way in that it protects you. A valid, a well-drafted contract with your partners ensures that there's certainty and clarity with respect to what what the relationship needs to be, and also it provides you protection. It provides you protection when you actually need it, particularly if things start to go south. I mean, that's the time when everybody starts pulling out the contracts and looking at it. And it really functions as a fallback insurance policy because you'll have the benefit of what you agreed to up front, and you'll know what the relationship was intended to be. I see somebody has asked a question about obtaining certificates of insurance, particularly from contractors. So we can get into that a little bit later, but generally speaking, you should, depending on the contract, ask for certificates of insurance. You generally want to see those, particularly to ensure that somebody is complying with their contractual obligations, but we'll talk about that more later on. So again, just to go back to this slide and finish it out, really we want the contracts so that we can absolutely, in circumstances when things go bad, know how things are going to shake out from a legal perspective and remember exactly who was supposed to do what. So what is a contract, right? Seems pretty simple, but just so we're all on the same page, a contract, it's a legally binding document generally between two or more parties, that sets out the rights and obligations of the parties. And I mean, we're not going to get into the legal definition because that's not really what this is intended. But, generally, this is what you're looking at with a contract. You have to have two parties or more. You can have as many parties as you want to a contract. Although, as you can imagine, the more people that you get involved, the more difficult it is. But really the goal of the contract, again, is to set out the rights and obligations of each respective party so that there's no questions later on with respect to who's supposed to do what in the relationship. And contracts are something that you all see on a daily basis. Even sometimes you just don't realize that what you're dealing with as a contract, because it doesn't always come across your desk as a nice formal document with, a very threatening look on the front of it. A lot of contracts are just ordinary day-to-day relationships. It can be something as simple as a purchase order for some goods or some supplies, right? But some of the more common ones that I think people are used to seeing in the nonprofit world are non-disclosure agreements, service agreements, lease agreements, employment agreements, and website terms and conditions. And I know, particularly with respect to the last one, again, like you come across these on a daily basis, and you never really think about, oh, I just clicked on a website and accessed it. Oh, I just actually entered into a contract, right? Like you are now subject to the terms and conditions of the use of that website. So again, contracts pop up at any time on a day-to-day basis. I see somebody's asking what is meant by a non-disclosure agreement. So in certain instances, you'll enter into a confidentiality and non-disclosure agreement. I think, Bark, I don't know if your note says that you want to answer that question. But basically the point is to keep things confidential, right? And so in some instances, you may be sharing information with another party, whether it's donor lists or something of that nature. And it'll be subject to confidentiality restrictions and restrictions on the ability of how the other party can use that information. I think service agreements, you're probably really familiar with this. A lot of software is now takes the form of service agreements, software as a service agreements. In addition, you have contractors who perform work at your space, whether it's leased or owned. Sometimes, you might have an independent contractor who's helping you with fundraising activities. So, again, you deal with contracts probably a lot more than you even realize it on a day-to-day basis, because they don't always come across as something that's threatening and in your face. So what are the elements of a contract, right? And so, you see these on a day-to-day basis, and you probably don't even think about the fact that, they generally have some pretty distinct parts. So I'm just going to take you through the main elements. The first element is the preamble. So this is literally just the beginning of the contract, and it really sets out some very basic background pieces. One, it sets out what the agreement is, whether it's a service agreement or a confidentiality agreement or a non-disclosure agreement. It generally says that in the very first sentence, what type of agreement it is. If it's a well-drafted contract, generally it'll tell you the date in which the contract is effective or the date on which it's going to be signed. And then it sets out some important information with respect to the parties. And generally in the preamble, you want to make sure that the contract defines not only who the party is by their correct legal name, but also the type of entity. And if you're dealing with a corporate entity or a limited liability company or a partnership or something like that, generally you want a description of what the entity is and where it's formed. And the reason you want that is because if things go really poorly and you end up in a lawsuit, or you end up starting to contemplate a lawsuit, you don't want to have to be trying to figure out who you've contracted with and who you're about to get into a lawsuit with. You want to know where they are, because that'll determine where a potential lawsuit ends up getting filed. And you never want to be in a position where you're having to track down and figure out, oh, is this the right corporate entity? I think sometimes people get a little lax here when they are actually putting in the party names, and they're just like, oh, we know what we mean. Well, that's not always the case. So please always make sure that you know the exact legal name of who you're contracting with, so that if things go poorly, you don't spend a lot of time trying to figure out who it is. Sometimes in the preamble, you'll also see parties' addresses. And generally that's because it'll set out where either invoices are supposed to go or where notices under the contract have to go. There's nothing wrong with that. You can absolutely put those in the preamble. And sometimes you'll also see that parties have assumed names or names that they're doing business as. And so generally speaking, you can see that as well, but please always make sure in your contracts that if you're referring to a DBA or if you're referring to an assumed name, that you always have the legal name in there as well. Don't just put the assumed name or the doing business as name, because again, like if you ever end up in a situation where you're having to track that party down, it's a lot of effort. And sometimes you end up in a situation where you don't know if you have the right party, if you've identified the right party when you're going to file a lawsuit. And so again, it's already when you get to that point, it's already a really stressful event. And you don't want it to be any more stressful than it has to be. You want to be able to know who the party is and be able to figure out where you're going to sue if you have to sue. Generally, after the preamble, what you're going to see is you're going to see the recitals. The recitals generally also start with like the word whereas. Sometimes they actually have in bold terms at the top recitals. So they should generally be able to be pretty easily identifiable. And the purpose of the recitals is not necessarily to put contractual terms into it, but it's more intended to tell the story. It's intended to tell the story of why the parties are entering into this contract. So for a services agreement, generally you'll see something really simple where it says, the service provider is good at performing the services, and that you want to hire that service provider to perform the services in accordance with this agreement. Sometimes there's a lot of background information to relationships and why you're entering into a particular contract. And so again, like anything that you feel like later on would be important to explain why the contract was entered into can go into these recitals. The recitals generally are not considered to be part of the contract itself, and that it's not a legally binding obligation. If you put something in there that you want to be actually legally binding, you would need to add language later on that actually incorporates the recitals into the terms of the agreement. So just always make sure that you have that incorporation language if there's something really important to the contract that's in the recitals. But otherwise, the recital should really just be describing why you're entering into the contract. The next section is the meat and bones of the contract. And it's where you should spend the lion's share of your time when you're negotiating these contracts or even just putting them together. But generally speaking, it's going to have some distinct parts in the agreement. It's usually pretty identifiable because it'll start with now, therefore, or some kind of canned language about good and valuable consideration, which is important. And sometimes at the very, when it's getting ready to go into the agreement section, it'll actually say agreement in bold right above it. So it should be, again, pretty easily identifiable. And it should lead in with this good and valuable consideration, the receipt and sufficiency of which is hereby acknowledged language, or something similar to that. It's a legal point, but that language is how you establish that there is in fact a contract, that there's been valuable consideration given, which is an important element for a contract so that the contract is later binding. And then generally the agreement will actually just jump right in and it will start talking about what the legal obligations are on the parties. So in a service agreement, generally the very first thing is it's going to say the service provider will perform the services to you pursuant to the terms of this agreement. And then it'll go further and it'll talk about, payment terms, and it'll talk about other obligations, performance obligations, whether there are certain milestones that have to be hit on certain dates, or if there's a particular deadline that the services have to be performed by. And we'll get into that next. But generally speaking, this is the meat and bones of the contract where you're going to see a lot of the important terms and conditions. So, every contract is different. There's no set formula. and it really depends on the type of agreement that you're entering into. But, some really common provisions of contracts are, describing the goods that are being delivered or the services that are being performed. The payment terms, when you as a nonprofit are actually going to pay for those services, whether it's up on invoice, if you're prepaying for those terms, or if you're paying for them, after receiving the invoice within 30-day periods. Sometimes, it'll also set out discounts for early payment or other concessions that parties are willing to make with respect to payments. The payment terms can also set out interest in the event that payments are not made when they're actually due. Another term that's really common in the agreement and that I would always encourage you to incorporate is some type of term, a temporal scope for the contract, as well as a means to terminate the contract. And we'll talk a little bit more about termination later on. But generally speaking, you want to make sure that the agreement either sets forth exactly how long it's going to last, or it can be that the contract is just continuing on an ongoing basis, and you can terminate it by giving 15 days or 30 days or 45 days notice at your convenience. You may also want to think about putting in some renewal terms into it. And again, we'll talk about that later on when we're talking about maintenance of contracts. But one of the worst things is to have a contract that has a term and then you sign it and you forget all about it, and you come back 3 years later and you realize, well, the contract expired 2 years ago because it was only a 1-year contract. So you may always want to consider, depending on the term and depending on the continuity of the services, whether you want it to actually renew and the terms upon which you want it to renew. It's also really common for there to be a section that deals with representations and warranties. And we'll talk a little bit more on the next slide about what those representations and warranties can look like and what they can cover. But generally speaking, those are statements and promises about the organization and about your ability to enter into the contract, and various other things like compliance with laws. Generally speaking, you might also have some other covenants in contracts, and think of covenants as just future promises that you're going to do something. So for instance, there may be a confidentiality provision in a contract where you say, we will hold this information confidential and not disclose it. That's a covenant. You might also have an exclusivity provision in a contract that says, this service provider that you're hiring is going to be your exclusive marketing professional or something of that nature. So, generally speaking, again, all those would be in a covenant section of the agreement. One of the most important sections in a contract is the indemnification provision, if there is one in the contract. And we'll talk more about that later on. There's a whole slide that'll be devoted to this one. But indemnification generally just covers when another party is going to come in and make the other party whole for some wrong or some breach or something bad that's happened. With respect to, and then everybody's favorite is the boilerplate provisions. I am sure most people just skip over those and they think, oh, those don't matter. The lawyers draft them and they never come up. I will tell you that the boilerplate provisions are some of the most important provisions of the contract. They all exist for a specific legal reason, and you absolutely want them there. You want to make sure that you're covered, and we'll talk about specific boilerplate provisions like the merger provisions, the entire agreement provision, governing law, etc. But those are important from a legal perspective, and again, we'll get into those in greater detail later on. Sometimes in the boilerplate provision, you'll also see right of publicity language or a trademark license that allows another party, either a service provider or somebody, to say, yeah, we do work for this nonprofit organization. It's generally couched in such a way so that your service provider or the other party can market their services to other similar nonprofits. And they generally want the right to be able to say, oh, you've hired them to perform these services. You don't have to agree to it, but you should obviously be aware of anytime that you're granting a party the right to use your name, to use your trademarks, because you want to make sure that you're comfortable with that and that it's something that you want to be public. And then finally, buried in any section of the contract, whether it's in the boilerplate, the covenants, or earlier in the agreement, there can be limitations of liability, or what from a legal perspective we call exculpatory clauses. And generally speaking, you just want to be very careful about that, because you always want to make sure that it's not restricting you in such a way that if something goes really badly, that you can't get a full recovery for whatever the other party has done that's wrong. You always want to make sure that the limitations of liability make sense from the relationship perspective. So just to kind of go back to what we were talking about a little bit, I mentioned the representations and warranties being an important part of the agreement. What are the representations and warranties? What do they usually entail in most of the contracts that you all deal with? Again, representations and warranties are generally statements about a certain condition and promises as to the continuity of those statements being correct in the future. For most part, the representations and warranties that you all are dealing with tend to be pretty simple. They tend to say, the organization is duly incorporated or duly formed under the applicable laws and is in good standing of the jurisdictions. And again, that's just establishing that the nonprofit actually exists under applicable laws, and that it actually isn't just a band of people masquerading under a name. You also generally see a language in there that says, you're representing, warranting that you have all the approval rights and legal authority to operate your nonprofit. That one's pretty self-explanatory, but it just means that you actually have, to the extent that you need any type of licenses from the government, or that you've actually obtained 501c3 status, that you've done those things. Corporate authority just means that the organization has actually obtained whatever authorization from the nonprofit necessary in order to execute the contract. So whether that is, the president of the nonprofit has approved it, signed it, whether it's something that needs to go to your board of directors for review and approval, depending on what your governance documents say about corporate authorities, you just always want to make sure that you have the requisite authority to enter into the contract. Sometimes you might see a representation warranty about your ownership and right to use intellectual property, and that your right to use the intellectual property doesn't infringe on any other third parties' intellectual properties. Again, that just goes to your ownership of your name. And generally the other party just wants to know that, again, if they're using your name, or if they're, for purposes of using your name in advertising, that if the service provider uses your name, they're not going to get hit with a cease and desist letter or some type of nasty gram from another unrelated party claiming that you didn't have rights to use that trademark. And then finally, it's not uncommon to see a representation and warranty that you're complying with applicable laws. That, again, pretty self-explanatory, but it just means that, by entering into the contract and performing your obligations under it, you're not violating the laws that would be applicable to the 501c3 or at large. Representation and warranties are a two-way street. So generally speaking, most of these are core representations and warranties that you'll see in the contract, and they tend to be representations and warranties that each party can give. So, in some instances, there may be some additional representations and warranties that you might ask from third parties that you're contracting with. But generally speaking, again, these are pretty core. So, and generally would not be subject to a lot of negotiation, or frankly to a lot of discussion, because they're so customary at this point. When we were going through kind of the list of items that would be covered by the agreement, we talked about covenants. And again, I know I mentioned briefly some different types of covenants, but here's a list of things that can generally pop up. We talked specifically about the exclusivity. So to the extent that you're hiring, a service provider, and they're going to be the exclusive service provider for a particular category of services, that would be covered under the exclusivity. In some instances, you may grant a service provider a right of first refusal in order for them to basically offer services at the same rate that another service provider is willing to offer. This can also come up when you're doing real estate transactions, if you're getting ready to buy a piece of land or something of that nature. But generally speaking, what it requires is that if you're going to contract with another party, you have to first give the right to enter into the contract on those terms to whoever you've granted the right of first refusal to. Similar with a right of first offer, and again, this pops up in service provider contracts sometimes. Generally, it's just if there's a new service that you need to provide, that you need to obtain, you will give the service provider an opportunity to provide that service first before you start shopping it around and asking other people to offer those services. Less common in the nonprofit world, but not completely unheard of. You might see non-competes and non-solicits. Probably those are more common in employment agreements, frankly, because generally speaking, you may want to lock up the president or other executives of the nonprofit or other key persons from competing or from competing with your business, going to one of your competitors, or frankly, from going to one of your competitors and then soliciting your employees to leave your employment and going to work for that new organization. And, core to the contract and what I'm sure a lot of you are used to dealing with are confidentiality provisions. And again, this is really common, particularly when you're sharing like donor lists and donor information. Generally, you want that information, because it is so sensitive, to be subject to confidentiality. You don't want people just publishing that online and telling everybody who your donors are in some instances. You guys, I'm having trouble. There we go. Okay. Next, and I know I highlighted this in the original structure, but indemnification. If the 6 asterisks aren't enough to tell you that this is important, this is important. Generally speaking, you want to go over these with a fine-tooth comb and make sure that you understand them. You want to talk to your lawyer about them and make sure that you understand what the contract's requiring. So generally speaking, from a high level, what indemnification basically means at its core is a party is going to stand in and make you whole in the event that something goes really, really wrong with the contract. So let's just say that you share your donor list with a service provider because they're helping you with something. And that service provider inadvertently or in bad faith releases all of that donor information to the public, posts it on Facebook, does something really egregious like that. There could be a lot of ramifications for that. And so what an indemnification provision does is it comes back and it says, okay, whatever the damages that the business has sustained from that breach, the other party has to make you completely whole for that. Whether that is, if let's just say credit card information for your donors is released, right? So you may have to take steps as far as, providing credit monitoring services, for instance, for your donors, right? And so an indemnification provision would allow you to pass that over to your vendor and say, you have to actually cover that expense because we're only incurring that expense because you failed to live up to your obligations under the contract. Generally speaking, indemnification provisions are not subject to limitations of liability or other exculpatory provisions, because generally an indemnification provision covers you for actual losses that you have sustained. So again, you'll generally see when you look at like limitation of liability provisions, you'll see lead-in language that says, except with respect to your indemnification obligations pursuant to section X of the contract. And that's important because, again, if you have an actual damage that you have incurred and that you're having to pay for, you always want to make sure that somebody is standing behind it and going to make you whole because you didn't do anything wrong to incur that. And you want to make sure that the other party is going to stand behind that. Sometimes with respect to indemnification provisions, you'll see really robust notice provisions. So, again, not uncommon So, you shouldn't be taken aback by that. Sometimes there, these indemnification provisions can be a page or more long. And, the point is, you just need to make sure that you understand the terms of them and what you have to do in order to trigger the indemnification, so that you're tracking that in the event that you have a potential claim under the indemnification provision. Because what you don't want to do is lose your rights by failing to give notice. The most common situation, frankly, where this comes up is a third party sues you because of what the service provider has done. And in a lot of instances, the indemnification provision will have a defense clause in it that says that the service provider is going to defend you, and they have to get counsel subject to your approval to defend you, and they have to pay for that counsel to defend you in that litigation. So again, these are pretty complex provisions, but important because it ensures that you always are going to get made whole when somebody else does something really bad and you actually are truly harmed by it. I mentioned the boilerplate provisions early on, and I know a lot of you probably see this provision of this section of the contract and your eyes glaze over and you're like, I'm not going to read those. Nobody's read them. Da, da, da. There are generally a lot of really important things that are buried in here. I cannot tell you how many countless times these boilerplate provisions have actually saved clients, even though they didn't pay attention to them at the time. I'm not going to go through these in a great level of detail. Most are self-explanatory. The entire agreement provision, just so you understand it, it just generally means this written contract that you're signing is it. This is the entire agreement between the parties. Everything is incorporated into it. There's nothing outside of this contract that we've agreed to that's not set forth in the four corners of this document. The governing law generally sets forth the state law that's applicable. Contracts are a creature of state law. So if you're entering into a contract in New York, New York law governs. If you're entering into a contract in Ohio, Ohio law governs. And there are, as you can appreciate, differences between the law in New York and the law in Ohio. So it's always important for everybody to understand which law applies. Venue just means if there's a lawsuit or a dispute, where that's going to get resolved. Generally speaking, you don't want to have to go chasing somebody in, a service provider that's working in California. You don't want to have to go out to California to sue them. You want to be able to sue them in the state that you're sitting in because it's just easier. You generally have a relationship with an attorney. And so it's just easier if you set out early on, like if there's litigation, this is where it's going to happen. Sometimes you'll see a waiver of jury trial, which just basically says we're going to let a judge determine who's right and who's wrong in a dispute. You'll see a provision that says, particularly in service provider contracts, we're independent. This is an independent contractor relationship. There's no partnership here. There's no joint venture, no employee-employer relationship. So that's really common. There will be a notices section that says if there's a problem, if there's a notice that needs to be given, this is the methodology by which you give notice to the other party. The non-waiver provision generally tends to be really important and tends to be the one that comes up most often after the fact. And we'll talk about that a little bit more later on. But this provision generally says, just because, one, we don't waive anything unless we say in writing that we are waiving it. So you have a right under a contract and you may not seek to enforce that right. That could be construed to be a waiver of that right. And what this non-waiver provision generally does is it says, we don't waive anything unless we agree in writing, signed by us, that we are waiving that right. And if we do waive something in one instance, we are not waiving that obligation in any future instances. So again, you might make a decision in a specific isolated incident that you're not going to require compliance with the term of the contract. What you don't want it to do is to be an outright waiver of that entire obligation in perpetuity for the life of the contract. Generally speaking, you'll see a provision that says, either a contract can be assigned or it cannot be assigned to another party. You'll see a provision that says, each of the individual provisions of the contract are severable. That means that if for some reason one of the provisions of a contract is unenforceable from a legal perspective, that doesn't impact the rest of the contract. It doesn't render the entire contract void. It just means that that provision that's not enforceable is just going to be ignored for purposes of interpretation of the contract. Sometimes it'll go a little further and it'll say, if there's a reason why a provision in a contract is void, then, a court has the authority to basically craft a provision that's as close to the existing provision as possible in order for it to be interpreted as legal. So that can get in depth, depending on the circumstance. In some instances, you'll see an attorney fee recovery provision. And I put an asterisk on this one because it's always, it always is really dependent upon the relationship and whether or not, you want to potentially be exposed to an attorney fee recovery yourself. These provisions tend to be reciprocal. So the provision literally says if either party brings litigation against the other party for a breach of the contract, whoever prevails in that litigation gets to recover their attorney's fees. So, if you're in litigation, you never know what's going to happen. But it could in fact be that, even if you think you're absolutely right, you can still lose in litigation. And so an attorney fee recovery provision always has that risk exposure that if you lose in the litigation, you could have to pay the attorney's fees of the other party. But flip side is, if you win, then the other party has to pay your attorney's fees. Absent an attorney fee recovery provision, generally speaking, your attorney fees are not recoverable in litigation for a breach of contract claim. There are some exceptions in various jurisdictions, but that is the basic rule under the American system is absent a contractual provision saying that you can recover fees, you cannot recover fees. And finally, it's really common to see a provision that says, we can execute this contract electronically. A lot of people have started using DocuSign over the last 5 years. Yes, DocuSign signatures are generally enforceable. There's a federal statute that says, electronic signatures are enforceable. But to bolster that, generally speaking, attorneys will want to see a provision that specifically says contracts can be executed electronically. I see that somebody has asked a question about the boilerplate provision related to the governing law and what happens when you have two parties who are in different states. So basically the answer is, this is generally part of the negotiation, right? I always insist that my client's state is the one that has the governing law clause, and says that, the state of Ohio or whatever my client's state is the governing law that controls the contract. Sometimes, honestly, from a practical perspective, it won't matter. Particularly for neighboring states in the same regions, the case law related to contract matters tends to be pretty similar to each other. There's not a lot of disparity between them, but it's something that you should always ask the attorney about whether or not there's a difference, a true substantive difference between the contract law of the two individual states that are at issue. If you can't reach an agreement, and if there is a disparity in the law between the two states, what will happen is generally people will pick a neutral forum as the governing law. A lot of times sophisticated parties will go to either Delaware governing law or New York governing law in order to just try to address that situation. But yeah, it's this. I appreciate the question, and it is something that comes up all the time when you're negotiating contracts, particularly with people who actually read the boilerplate provisions. But like I said, it can be important if there's a huge difference between the substance of the laws of the two states. And so really that's where you need the lawyer to really tell you, is there a real risk there? And should we pick a neutral jurisdiction that we need to go to? So thanks for the question. I see that we have a second question from one of the participants about negotiating authority and abilities with large corporations. particularly with respect to when you're dealing with a small nonprofit. And so it really, I hate to give you the most lawyer answer that's out there, but it really depends. It depends on the type of contract, and it depends on the other party. If it is a service that you can only get from that corporation, or if it's a relationship you can only get from that corporation, and it's a really large corporation, you can appreciate negotiating that can be really, really difficult. And in some instances, they won't negotiate. Now, generally speaking, a lot of people will say these are our form agreements, we won't negotiate. But if you push them a little bit, especially on a couple of key core pieces that you think are really material, sometimes even with large corporations, you can get some type of agreement, and it's not just a what we call a contract of adhesion, where they force it upon you and say, we're not changing this. A lot of corporations will have discussions with you. And if there's something that's really key to the deal, particularly in a way in which you are different from their other customers, generally speaking, it can be a discussion. And I have seen, particularly in the nonprofit space, for corporations to bend a little bit more easily when they're dealing with nonprofit corporations because of the charitable benefit that those organizations provide to society. With respect to mandatory arbitration provisions, which I appreciate is the second piece of your question, my experience is that once arbitration is put on the table as a potential deal term, a lot of people gravitate toward it, because a lot of people tend to think that arbitration tends to be faster, easier, and frankly, cheaper to resolve disputes. So generally speaking, in my experience, it doesn't matter the negotiating leverage between the two parties. I think once people start talking about arbitration, putting that out there about the desire to have a mandatory arbitration provision, I think people tend to latch onto it pretty quickly, because people appreciate the cost savings associated with that. I mean, and that's underlying all of this, right? Because with it doesn't matter how perfectly drafted your contract is, if you end up in a really bad situation with litigation with the other party, it's expensive. Litigation is expensive. And so people are always looking for a way in which you can avoid that expense. And so an arbitration provision is one way in which people generally will gravitate to avoid those expenses. So good question. Generally speaking, the last thing that you're going to see in the body of the main contract is going to be the signature page. And again, equally important part of the contract, it says, here are the parties and here are the people who are signing on behalf of the applicable entity. If it's a corporate organization, you generally want their title, and you want to make sure that it looks like a legitimate title of somebody that you would expect would have authority to execute the contract on behalf of the organization. Just as a practice pointer, on the signature page, I also always make sure to say specifically what the agreement is. So like for here, in this instance, it says this services agreement. Some people on the signature page will just defer to the defined term agreement, and so it'll just read this agreement. And sometimes the signature page gets separated from the contract. So I always encourage clients to say specifically what the agreement is. If it's a service agreement, if it's a non-disclosure agreement, if it's an employment agreement, if it's a lease agreement, say it on the signature page so that it's really clear what the signature goes to in the event that you're executing separate signature pages, or if you're executing in counterparts. So from a practice pointer, what are some items that you want to avoid when you are negotiating and entering into the contract? Number one, ambiguous statements, right? We talked about this at the very beginning of this. Like, the whole reason for a contract is so when there's a problem, you can open the document and it will tell you what's going to happen. So you want to have as much clarity as possible with respect to the contractual obligations. You don't want ambiguity. You want everything spelled out as much as possible so that there's no question about who's right and who's wrong. But the flip side of that similarly is you don't want just a bunch of fluff. If something's not important, if something doesn't actually impact the relationship between the parties or isn't necessary to understand the relationship from the parties, don't put it in the contract because you're just junking it up. And it might end up being something that could get interpreted later on as an agreement that you didn't intend for it to be. So you always want the agreements to be streamlined and clear as to each party's obligations. Something that's really common in contracts, and it's literally the worst idea possible, are website URLs. So a lot of times, particularly when you're purchasing goods through through a purchase order, there will be references to like terms and conditions on a website, and it'll say, this is subject to the terms and conditions available at www.whocares.com/ this is never going to be what it's actually going to be in 10 years. And therein lies the problem. Websites are not static, right? Documents that are on websites can be updated, they can be changed. And so, it can be a real hassle later on when you're trying to figure out what the terms and conditions are that you agreed to, because the terms and conditions that are on that website or the privacy policy that's on that website might have changed. And you might not know when it changed. You might not know which version was actually on the website, or worse, you type in the website and it takes you to a 404 error page and there are no terms and conditions. And then you really have no idea what's going on, right? So in the event that there are terms and conditions that somebody that you're contracting with has on a website, and they really want those terms and conditions incorporated into the contract, don't reference the website. Print the terms and conditions and attach them as an exhibit so that it is clear exactly what was agreed to at the time the contract was entered into, so there's no question later on. And in a similar vein, make sure that the contract, if it lists documents that are incorporated into the contract or that are important for the relationship, make sure that those documents are actually attached to the contracts. And so generally speaking, you can do this through a series of different mechanisms. You can either have an exhibit that says like Exhibit A, terms and conditions, or Exhibit A, privacy policy. Sometimes you'll see people refer to them as appendixes. You'll see them referred to as schedules. From a legal perspective, those distinctions don't matter. You just want to make sure that the underlying agreement references the exhibit and says it's incorporated into the contract, and then make sure that there's an exhibit and that it's attached. I see somebody has asked another great question about the difference between a memorandum of understanding and a contract. So again, the answer is it depends. It depends on whether or not the memorandum of understanding is intended to be binding or non-binding. Generally speaking, if you sign a memorandum of understanding, unless it says that it's non-binding, surprise, it is a contract. You are agreeing to something. So it's no different from a contract. It can be legally enforceable and binding on the parties. So a memorandum of understanding generally is a contract. Again, though, the exception is if it's truly something that is still being discussed, and the purpose of the memorandum of understanding is to kind of set forth the structure of the relationship moving forward while you're negotiating a larger contract, then generally speaking, you want to make sure that there's language in the memorandum of understanding that says this is non-binding. This is not a contract. No party is bound by this. This is just a description of intent, and the parties are negotiating a larger contract. But absent that, if you sign a memo of understanding, it's a contract, it's binding. And so you want to be really careful about what you're entering into in those circumstances, and don't assume that it's not binding and enforceable against you. So somebody just asked another great question, which is if two nonprofits are working together on a project or program, sometimes they'll refer to each other as partners, and the agreement is referred to as a partnership agreement. Is that okay? And the answer is please don't. And the reason is because generally under applicable law, partnership has a very specific meaning. A partnership refers to an actual legal organization that involves two or more people. And if you don't intend to actually form a partnership, i.e. a legal entity in which the two of you are truly partners and it's some separate endeavor or joint venture, don't refer to it as a partnership. Refer to it as, even if you just have to refer to something as an agreement because you don't know how else to style it, or you can't come up with anything else that just sounds very flowery and great, just call it an agreement and do not call it a partnership agreement. But generally speaking, you can come up with some other descriptor that can just be used generically other than partners or partnership. Because again, those terms have a very specific legal meaning. And every time I see people referring to each other as a partnerships, 99% of the time, they don't mean it. And I cringe every time. So just please avoid that. It is important from a legal perspective because you don't want to be deemed to be creating a partnership with another organization. So the next part of the presentation is, what happens after we sign? And I apologize, guys, we're running out of time, so I'm going to start speeding along. So if anybody has any questions, I will feel free to go ahead and ask them, and we'll keep doing this. But what do we do after we sign a contract? One, make sure you are following the contract. Both make sure you are following the contract and make sure the other party is following a contract. And the reason why that is so important is because contracts can be amended from time to time if you are not following them, if you are doing something else. And there's, it's called, generally speaking, course of dealing or course of performance or similar verbiage. But basically, if you have this beautiful signed contract and then the parties are just doing something else for years, basically it can render the contract kind of meaningless and unenforceable with respect to those provisions because the contract has been modified by the way in which you have actually been acting. So you always want to make sure that you're tracking the contract, that you're not diverging from it, because it can have ramifications and then you've wasted all of your time negotiating the contract. Also, we talked about making sure the contracts have temporal scopes, that they have a specific term. Make sure you're keeping track of those. And that, to the extent that, a contract continues on beyond that term, that the contract itself is getting renewed and that you're tracking any renewals. So that if you want to get out of a contract, you know when you need to provide notices to get out of that contract, or, if you want the contract to continue, that you're providing whatever renewal notice is necessary for the contract to continue. Because there's nothing worse than, again, getting out 3 or 4 years and realizing that, for the last 2 years, you haven't had a contract because it expired and nobody sent a renewal notice. Because then you might be at a mercy for whatever standard terms and conditions are out there that the other party has that apply to all of their other customers or relationships. Also, just make sure that if the other party is not doing what they're supposed to do under the contract, that you're providing notices to them, because that's generally how you're going to trigger obligations with respect to them curing their breach, or otherwise triggering your termination right in the event that their relationship is just not salvageable. And the same thing with indemnification notices. Generally speaking, there's a covenant in the contract that says if you have an indemnification claim, you have to give the other party notice within, X amount of days. So you want to make sure that you are giving those notices in accordance with the contract so that you don't inadvertently waive those rights. What happens when there's a problem, right? What do we do? And the answer is read the contract and follow it, right? And if you've drafted a contract and you've spent a lot of time doing it and everything's proper, the contract should give you the answer as to what happens in a particular circumstance. And you should never hesitate from saying, this is what the contract says, and this is what we're supposed to do. And generally speaking, the other party really, they don't have a response to that unless, the contract has been terminated or unless the performance of the party has been different from what the contract has said. And again, that's where that prior slide becomes really important about making sure that you and the other party are tracking the contract and doing what it says in it. Also, when there starts to be a problem, and even before there's a problem, just be really careful about what you're saying and what you're writing. because the reality of it is, in certain instances, contracts can be modified by what you say or what you write. And even if it's not modified, those communications can come back to be used to either supplement the contract later on, or to say, this really wasn't an issue, or you knew it was an issue and you didn't care. And so, when you're actually communicating about performance under contracts and the terms and conditions of the contract, you always want to be really mindful and think about, if this goes really poorly and this ends up in litigation, what I am saying right now or what I am writing right now, how is that going to impact us later on? So you really have to just walk that line and make sure that you have to have a little bit of foresight on, if something goes really, really poorly later on, how is what I'm doing right now going to impact that later on? And never shy away from insisting on having the other party actually comply with the terms of the contract. Again, you negotiated the contract with the other party, you agreed to those terms and conditions. They should not have a problem with complying with the terms that were agreed. That shouldn't be controversial, generally speaking. But if things start to really go off the rail, or if you find yourself in an uncomfortable situation, always consult with your attorney or talk with PVPO. And I'm sure there are resources to help you get that consultation and assistance that you need. But just please, if it's something that you're not sure about what the contract means, or if you think that the situation is getting really dicey, get the attorney involved sooner rather than later. I know sometimes, with resources, you want to avoid the expense associated with it, but it's one of those things where you could really pay for it later on, and you don't want to be penny wise and pound foolish. At some point in the contract, you might need to modify it because the relationship has changed, or additional services are being provided, or the scope of the contract, the term of the contract needs to be extended. And so what do? Put it in writing. Always make sure that if the contract is changing, that you are putting it in writing. Make sure that writing references the underlying contract and describes the circumstances of the modification, so that there's basically a record, that there's a train that you're on that specifically says, this is what the circumstances were for the modification, and this is what we agreed to, and this is how it modifies the underlying document. Generally speaking, you don't need to just restate the entire contract in the modification unless the entire relationship is changing, or there's whole sections of the original contract that are being deleted out. And so in some instances, you might want to do an amended and restated contract to say, okay, this amended and restated contract is replacing the prior contract, and this is now what is in effect between the parties. How do we terminate the contract? This is when things have really gone bad, generally speaking. There are three different things that you generally look at. One, mutual termination, where both parties realize, this just isn't working out, right? And so you just basically agree to terminate the contract. So it's kind of a separate agreement between the parties where they agree to literally go their separate ways, terminate the existing contract. That needs to be in writing, guys, right? So even if it's just a one pager, you always want to say, the parties agree that the contract, dated X, is no longer in effect and is hereby terminated. Both parties sign, boom, you're done. Generally speaking, particularly with service providers, you'll want a termination for convenience provision in your contract. And what that basically says is you can get out at any time for no reason, and you don't have to have cause. It doesn't have to be that they've breached. You can literally just give 15 days or 30 days or 60 days notice and get out of the contract without any financial penalty. Generally speaking, these provisions tend to be pretty mutual. So, you always have to weigh the benefit of your ability to get out with the ability of the other party to exit the relationship, and the impact that would have to the business as well. And then finally, worst case scenario, your termination for cause provision. And generally speaking, this is the provision that everybody looks to when something has gone very badly, but nobody can agree to just exit the relationship. And this is where, you generally have to give notice of the breach by the other party of the contract. And they generally will have, a cure period at which they can try to make it right. And if they don't make it right, then you can terminate the contract for their breach. This tends to be the most controversial type of termination. and can sometimes result in litigation because the other party will say, no, we never breached. We're contesting that we breached. We're contesting that we didn't cure a breach. And so you end up in a really messy legal battle over whether or not you actually appropriately exited the relationship. So, again, avoid that third section as much as possible. Hopefully you can either get to a mutual agreement to terminate, or you have a termination provision that allows you to get out for your convenience just by giving notice without having to give any reason for getting out. So guys, that's it. That is the presentation. I know we've answered a lot of questions seemingly throughout this process. I don't know if anybody else has any additional questions about the presentation or anything else that they would like me to cover. But I'm always happy to be a resource, or obviously Pro Bono Partnership is out there to help hook you up with lawyers who can help you negotiating these contracts or giving you advice and counsel with respect to them, or answering any other questions. Barca, I see that you have come off mute now, so I'm assuming you're going to jump in.
Yes, Jerrad, thank you so much. Again, everyone, Jerrad Howard is a partner here at Dinsmore and Shohl. Jerrad, thank you so much for making this relevant and engaging for us and our nonprofit community. If, as Jerrad mentioned, you have any questions, feel free to reach out to your PBPO attorney, and we're happy to work with you on those. And again, Jerrad, thank you so much. Thank you everyone for joining us today.
Thanks everybody for sticking around and listening to me.